we doing, everybody?
Hello.
Jess.
I know. Long time no see.
I know it's been a while. Welcome, everybody, to the premiere of Barely Interesting. Welcome. I told some people in the chat that were asking me where the name came from. I said they had to ask you, Solomon.
So there was a long-standing debate about this, and I think was it Jen that brought it up originally, but it was spelled bear, B-E-A-R, like bear.
Let's not talk about the spelling now.
Because Zach's nickname was Z Bear, so it was sort of the play on words of the Z Bear, barely interesting, but sort of the sarcastic approach to it, but barely as a nod to the Z Bear comment in the text from the courtroom, if that makes sense.
And welcome Jess as our third host for today. How have you been?
I'm good. I actually just I decided to create a new true crime YouTube channel of my own. My first video is going to be on Zachariah's case. So
nice. This is a perfect warm-up for you. This is like a trial run then. So Solomon and I, we started restreaming the Zachariah Anderson case, 9 a.m. Eastern, 10 a.m. Central, right? Is that right? No, 8 a.m. Central.
It's 8 a.m. Central.
8 a.m. Central. It's early for you guys then.
Yeah, it is.
And so we're here. We're going to talk about a little bit about, we'll say, episode 1 and 2 of the Zachariah Anderson trial, which amounted to the state's opening and then a long argument regarding Denny. And it's not, forever be soup. It will forever be soup. I know. I saw C-Swep's comment in there. But okay, so Solomon, you had some comments about just the prosecutor in general. I have some thoughts about the Denny motion. I guess maybe we can discuss that first, since that seemed to be the topic of Bronca as well.
Yeah,
and we can clarify some things. Okay, so in Wisconsin, before you can point the finger at someone else, specifically a person, that's the idea behind it, you need to get approval from the court. And the court has a 3-pronged test that you as the defendant have to meet. And that is that there is direct evidence connecting this specific third party to the crime, that the third party has the opportunity to commit the crime, and that the third party had motive to commit the crime. Fundamental problem I have with that right off the bat is that you're putting a burden on the defense, that they have to present this evidence if you're going to identify a specific person. Now, I will say that the Denny motion doesn't prevent you from arguing it wasn't me. It's like it was just some random person. Who knows? I don't know. But if you want to point the finger at a specific person, then you have to give prior notice. And that's what was being discussed during the opening statement. Or that's when the defense's opening statement was cut off by the state. But I don't think it was an actual Denny motion issue. The state and the defense, I feel like, were arguing two completely different things. They were on, the state was on Mars and the defense was on Venus 100%. At this point.
Yeah.
What I saw was what's her name? The defense attorney,
Nicole Muller.
Nicole was arguing that the state looked at these text messages, knew about these text messages sent between Sadie and her friend, and didn't investigate anything. And that's not that they were necessarily pointing the finger at Sadie Beecham as being the perpetrator, which is what the Denny motion is. The Denny motion is supposed to be targeting the perpetrator of the crime, not a perpetrator of another crime, right? The, threatening to break somebody's legs or teach them a lesson or whatever. That was alleged that Sadie and Rosalio were doing that against Zach, not that anything was happening to Rosalio. But I think the prosecutor took advantage of the phrasing that was made and said, well, this is a Denny motion. We need to have a mistrial and start all over again.
He tried to make an inference to try and argue to make sure that he could bar it from the arguments in the courtroom, to make sure that he tried to convince the judge to classify it as Denny, like that argument was somehow roundabout, backdoor connected to Sadie being the perpetrator of the crime. Now, whether or not there was validity to that claim is totally different. But also, as I think I said in the chat today, his case is so incredibly weak that he threw an absolute temper tantrum about this line of text messages that he had full knowledge of, that was in the discovery that they handed over to the defense. And that was
Right.
part of the purpose of the Denny motion, is to present to the judge, who's, for those of you out there, the gatekeeper of information, to then make the judge make a decision on whether or not it's admissible to the court record. And sorry, David, if I'm stepping on your shoes here.
No, and that kind of leads us into this next thing that I discovered. There's actually a new case involving Denny out of Wisconsin, newer. This is the State v. Green, 2023, Wisconsin 57. It was decided June 29, 2023. In that case, the Wisconsin Supreme Court upheld the declaration of a mistrial for a violation of a Denny rule. Let me give you the facts, though. So, in March of 2019, Milwaukee County District Attorney charged Michael Green with trafficking a child. Now, before the trial began, the defense counsel filed a witness list that included Mr. Green's cousin, who happened to be named Jonathan Cousin, interesting enough. So, defense counsel possessed also a written statement from Cousin, but the state never demanded that the defense counsel turn it over. All right, so the defense has a written statement from Cousin, and the state doesn't have it because the state never asked for it. Then in August 2019, the state filed a pretrial motion in limiting. A motion in limiting is to exclude evidence and things like that, requesting that the court bar Green from introducing any other acts evidence that involve third parties unless the circuit court ruled on the evidence. However, the court never ruled on that motion and never made a decision. So the trial starts, and Green calls Cousins to the stand. Cousins testifies that it wasn't Green driving the vehicle with the two victims in it, but in fact him. Cousins testified that it was me, it wasn't the defendant. During this testimony, the state does not object. State just lets it fly. Later on that day, after lunch in the afternoon, the trial judge calls the state and the defense into chambers and says, I think the defense may have violated Denny, and declares a mistrial. The state didn't even challenge it. The state said, you didn't get notice, or I mean, the judge said to the state, you didn't get notice, so therefore the defense has violated Denny. The trial judge declared a mistrial. Mr. Green filed a motion to dismiss this case with prejudice, and that was denied. And actually, interesting enough, the Court of Appeals reversed, and then the Supreme Court reinstated. So the Supreme Court even said, so in this particular case, the state didn't even object, but the judge himself said you didn't give the state notice. The whole idea behind the Denny motion is that it's a fair trial for the state, which right. The last time I read, the 14th Amendment or anything, when we're talking about due process, it doesn't involve the due process rights of the state. It involves the due process rights of the defendant.
Right. Because the state's not human and cannot be embodied. So why does the state suddenly have rights that need to be upheld by this law? Doesn't make sense. And it also it gives the prosecutor the opportunity to collude with the judge to then gatekeep information that could exonerate or provide an alternate realistic reasonable doubt argument about the accusation brought by the state. And this is why in Holmes v. South Carolina, I believe the 2006 case, which is a United States Supreme Court case, they argue that Denny and a unanimous agreement came through that Denny is unconstitutional. Wisconsin has so far refused to acknowledge and overturn the Denny law, and I mean,
And then they doubled down on it just last year.
right,
Last
exactly.
June. They doubled down and they said it doesn't even mean, or it doesn't even require the state to object. The judge can just do it.
Which is ridiculous in the situation where the defendant needs to try and prove or argue in an appeal to a case. The objection is what holds it sacred for the appellate court to then look at on a second turn. So if the state didn't object to it, why are they given the free pass? It doesn't make sense.
Yeah, I mean, we watch trials all the time, and people are like, "Well, isn't that a violation of this or that, or isn't that hearsay or leading or whatever?" Our answer is always the other side didn't object, so
Right.
the court just lets it go.
Right.
But they called it a manifest injustice, and I heard that word a lot in today's hearing regarding a manifest injustice to allow this random offhand statement that the prosecutor inferred as a Denny thing in the Zachariah Anderson case to let that stand and to not declare a mistrial. And first of all, it wasn't even a Denny issue because remember what we're talking about with Denny, and this is the State v. Denny, which is the Court of Appeals out of Wisconsin, is that if the defendant wants to identify a specific third party as the rightful perpetrator, then they must establish some sort of legitimate tendency to establish three things: that the person was somehow connected to the crime, that he had an opportunity, and that he had motive. But if you're just challenging the competency of the investigation, which is what they were doing in the opening statement. They were pointing out the incompetency of the investigation in the Zachariah Anderson case. That doesn't rise to a Denny motion.
Right.
And that's the fundamental problem I have with this objection.
It seemed like the prosecutor knew that was going to be coming up or something, because he was really quick to cut her off before she could elaborate and explain her stance and what she was meaning to say and the context of it, right? Because it's yes, with the context, obviously it's not accusing any one person. It's, hey, this wasn't investigated. It was a for instance as a viewer to me, but he was quick to cut her off and go full Karen, and it was like, whoa.
He did go full Karen, didn't he? Well, the other thing too is, so we watched day 2, right? So day 2, they had a whole bunch of things, but they had transcripts, and he read word for word and said, she's going to talk about, or what she said is you're going to hear about all the misinvestigation, including text messages and other suspicious individuals. And then she goes on to talk about Sadie Beecham. Judge, you can only conclude that Sadie Beecham is one of the suspicious individuals, and therefore she's pointing the finger at Sadie Beecham. That's not at all what she said.
Not at all. But the inference that she was shady, that she was a suspicious individual, was implied and intentional, I believe. And I think justifiably so, based especially on that exchange of text message that we're familiar with, where she's colluding with at least 2 people for a plan B, which included up to breaking one of my brother's legs. And that should raise an eyebrow to anyone that was objectively watching this, including the jury, which it seemed to go right over their head.
Well, and that's the other thing too. And then we'll move on to another topic. I just wanted to address that specifically, was the text messages didn't imply that something was going to be done to Rosalio to frame Zach, but that Zach was actually going to be physically assaulted. So how you can connect it to a Denny thing in the first place is beyond me.
Right, because it actually didn't include Zach or Rosalio as a member of the crime, and it didn't imply that Sadie had any involvement in Rosalio's disappearance. So it didn't apply Denny at all, not even a little bit. But the state's case was so weak that they were doing anything they could to try and block any argument that the defense could have that would then provide some sort of reasonable doubt about the integrity of their key witness, because there was really no one else that was going to be a reliable witness, and the stalking charge revolved completely around Sadie Beecham's testimony.
David, do you think that the prosecutor was looking for any reason to say mistrials because they didn't have enough confidence in what they had to bring to trial?
I was thinking about that. Why would he ask for a mistrial? We already had one mistrial. And like the judge, and I don't know this rule in Wisconsin, but apparently if the judge would have granted the mistrial and then the Court of Appeals would have disagreed with the judge, which he seemed to imply they would have, because this was a tenuous connection to Denny in the first place, then there would have been no further prosecution of Zachariah Anderson. He'd be a free man today. So understanding that, and Gravely seemed to agree with the judge when he said that. So understanding that, and then to push, I think he said 4 times, if I'm not mistaken, I want a mistrial, judge. And the judge refused to grant the mistrial at the end of the day.
And even told Gravely, and I quote, "If I grant this, you're done." That's what he said. He said, "You're done," which blows my mind, because that's clear for an objective viewer, and for me watching the trial as just a layperson at the time. I was like screaming at my screen, like, what is happening here? He's colluding with the prosecutor. This is clearly judicial bias.
Well, even with that, Gravely was like, I still want the mistrial, judge. Right. I don't know. Logically, I don't know. Maybe he was nervous. People sometimes get nervous. Everyone should get nervous before a trial. Even, people that do. It's like getting on stage. If you're an actor, they say, once you become comfortable on stage, then you're not going to be giving a good performance because you're just too lazy about it. And I feel the same way about trials. Like, I get nervous before trials, because you should be nervous before you're doing something that's kind of really important, even if you've done it a bunch of times before. And so maybe he was just really nervous about starting this trial the second go around, maybe because he knew he was on the witness list, maybe because there were stresses involving that. As you will find out on day 3 that he's on I think it's day 3 that he's on the witness list. He's actually excused out of the courtroom for part of this trial. So, there could be a lot of things going on with him, and that's why he just wanted a quick bail. I don't know. I honestly, I don't know, because there was so much to risk by asking for it.
I think that this actually segues into, the second topic, the thing that I wanted to bring up too. Jess, what do you want to focus on yourself? We didn't clarify that.
Oh no, I'm along for the ride mostly, but I did watch the first go round of the trial. I can't believe it's already been a year since that happened. So I've been catching up and refreshing and listening to the podcast to get extra context that wasn't included, and so I'm just re-immersing myself in it again.
Before we move on to the next topic, I do want to point out the podcast. Everyone, at least in my chat or in my description, I think it's in yours too, Solomon.
Yeah, true.
There's a link to Wrongful. You guys need to check out that podcast. It's an excellent podcast. Do we have the ladies in chat?
I see them in my chat for sure. Yeah.
Oh, here's Ashley.
Well, I see Alicia, Ashley. I thought I saw Josie earlier.
So the ladies from Wrongful are in the chat. It's an excellent podcast. Nice. If you want to know more about this case, check it out.
And Law Kong just dropped another newsletter today. So Law Kong. Oh. It's like a 90-minute newsletter. He really deep dived into a lot of things that haven't really been discussed, and he's done a lot of independent research, and it's a very, very good episode. So all of you out there, check out Law Kong Express newsletter. He just dropped. Was that episode 5, Joe?
I tweeted at you, sir, because I can't message you.
He and I were talking already about it. I got you.
Okay, all right. So I can't message him. I don't know. So Jess, rewatching this? What are your first impressions then? or your
Well,
re-impressions, I should say.
my re-impressions. Well, I went into it not knowing anything, right, initially, and I was following some of the law tubers that were streaming it. But really, I had no opinions, and it, it's always remarkable to me when you go into any trial and the prosecution gets up and they give their opening statements. And a lot of the time it's like, oh wow, that's plausible. Wow, what a crappy person. Like, and then it's like the defense gets up, it's like, wait a minute, that's plausible too. Okay, you're gonna have to duke it out for me because a blank slate and going into it with context and extra information, everything post, verdict. I'm looking at it a little more with more scrutiny, and I'm seeing, maybe it's just my bias at this point, but I'm seeing things on the prosecution side where I'm like, I don't know. It just, I don't know. I'm getting bad vibes, kind of like shisty, kind of underhanded. Just, I don't know. I'm getting weird vibes this time around from prosecution that I maybe not have picked up on the first. So.
Yeah, I found it interesting watching it the second go around as well. The first time I was watching it, and I listened to Gravely today like I did the first time, and I was like, okay, I can follow the story. But then once the defense starts talking and starts poking holes in this, that's when I really got interested in this case, and I was like, this isn't quite as cut and dry as Gravely made it out to be. What's going on here? That was my thought. But so speaking of Gravely, Solomon.
Yeah, so I've been doing a little bit of reading lately, and there is in like legal theory a concept of something called a bad man. And this is what seems like common sense to everybody. A bad man is someone that that intentionally acts to avoid consequence with the law. And it just rang so true for watching this trial for me that I really wanted to talk about it. I brought it up to David. Now, there was a paper written for anyone out there that wants to look into this. It was written in 1897 by Oliver Wendell Holmes, a Supreme Court justice, one of the most preeminent Supreme Court justices in the last century and a half. He wrote a journal, a legal journal, talking about the cross-sectionality of morality and legislature, like legal, the application of law, and the way the law conforms to morality as a society and how it's changed over time. And in this, he identifies the bad man as someone who intentionally acts outside of the rules of conduct established by society. Someone who knowingly, with full knowledge of the law, still chooses to take actions that intentionally avoid any sort of consequence, whether it be financial or physical. And he talks a little bit about a few different types of wrongs that can be committed. He talks a little bit about like larceny versus embezzlement. He talks about physical damage or harm. But all it kept bringing me back to is the moments in this trial where we have Michael Gravely looking at the judge, which happens more than once, and we'll bring it up later when he does this, and he goes, "I believe that's the line, Judge. I believe that's the line." And that exchange, when they're talking, is them both acknowledging that he's attempting to circumvent and use inference to betray the spirit of the law itself to get away with trying to get this wrongful conviction. And that only identifies him as a bad man in the way that Oliver Wendell Holmes defined it. And there is a difference between malice, negligence, and ignorance. There are three different types of act that can result in violating the law or violating the common law man. And he violates at least two of them, one with malice, with intent and full knowledge of the law, and the other with negligence of duty. And that's this. There's one quote that I wanted to read. It's not very long,
I
but
tried
it
to
says,
post a link to it, by the way, in your chat, but I'm not a mod. So
oh, David, I can make you a mod.
I posted it
Uh,
in mine, by the way. So if you guys see it in my chat, it's the article that Solomon's referencing.
so he says that that he says it is well to have an accurate notion of what you mean by law, by a right, by a duty, by malice, intent, and negligence, by ownership, by possession, and so forth. And then he says sometimes it is said that if a man neglects to enforce his rights, he cannot complain after a while if the law follows his example. And prefacing that, he says, you were discussing what the law ought to be. As the law is, you must show a right. A man is not liable for negligence unless he is subject to a duty. And all of these apply to this case. This theory of law that was written so long ago by this brilliant man. Now, there's issues with the theory of it. You can look at all those if you really want to dig deep into it. But the negligence of duty, you are not negligent unless you are subject to a duty. And as a prosecutor, as a representative of the state, you have a duty to uphold the law, to do it with integrity and honestly, right? This is part of the code that prosecutors are supposed to follow. And I see Michael Gravely violating that by defrauding the court, by violating constitutional rights, and by intentionally trying to sidestep the law for the sake of a conviction, as opposed to upholding the spirit of the law, which is a big part of what this paper is about, is making sure that we follow it.
Yeah, it's the spirit of the law. It's what we want the law to be. And what Oliver Wendell Holmes is getting at is that we want it to be a guide of morality rather than following the misfeasance of the actors within our society, essentially, is what he's getting at. And so you can't allow the bad man to control essentially the law and how it's applied, the application of the law, right? Because the law doesn't matter. It's the application of the law that really matters.
Right.
So that's what we're getting at here. And that's what the criticisms of Gravely have been throughout. And he's even gone on the record. Well, I don't know, not on the record, but he's actually gone out and said he wanted to do a no body case before he retired. This was a bucket list item for him, right? This wasn't about justice for Rosalio or his family or anything else. It was a tick mark in his box of things to do before I retire. Is that the type of justice that we want? Is that the type of person that we want exacting, the state's interest in that sort of thing? Can we sue him, Solomon?
No. and that's the biggest problem, is so that even though it's not protected underneath the Constitution of the United States, the Supreme Court ruled in 1971 that prosecutors should have immunity for the sake of removing the fear of the oath to duty. What they wanted to do is to remove the fear of consequence for maintaining the duty of their office, and what it's done and the verbiage of it and the rulings that they've made to uphold it since have completely undermined the consequence to bad faith prosecutions, and, as we've talked about, Brady violations, which was the first mistrial. Zach's first trial was a Brady violation by the state. And layman's terms out there, we were just talking about having a fair trial between the defense and the prosecution. Everybody is supposed to know about the information that's going to be presented. And what a Brady violation is that the state didn't turn over evidence to the defense for them to prepare an argument or to investigate independently and verify the veracity or the reliability of what the state is presenting. And with that, it's there's I forget what state v. Brady, but there's a Giglio. No, the Gigliotta list is different. But there's case precedents that identifies it as a violation of the right of the defendant because they weren't given the opportunity to present a fair and complete defense.
Right. They weren't given
So-
all of the materials available to prepare a defense.
Right.
And on that note, as far as like perverting the whole process, right? I mean, you have these people at the helm, have their duties to uphold, their passion and their interest should be upholding the law in the best interest of society or whatever, right? But giving them unbridled immunity the way that they have, what's the incentive? I mean, when there is a
Well,
shift in focus to
let
like,
me
political
quote-
gain and ticking the boxes.
Well,
that.
exactly. Let me quote a part. By the way, I put the citation in the chat for the case that we're referencing.
I did make you a moderator in my chat too, David. Sorry to side.
Mhm.
Okay.
Congratulations.
Did I finally?
Post it.
Yay! All right.
You can post the link.
So I didn't put a link. I just put the citation. But one of the quotes, and I can't find it right now. But essentially, what the court said is that we have to offer prosecutors absolute immunity because they are representing the interest of the state, and their focus must be on the interest of the state. Not they can't do that effectively if they're scared that every one of their missteps is going to be critiqued.
Mm.
That was the statement, that if their missteps are going to be critiqued, then they can't effectively represent the state. That was the justification for it. And I don't even know where to go from that. But that's what they're saying. And they have blanket immunity. This is common law, by the way. So let me explain. So this is common law, not statutory law. So statutes trump common law, and the Constitution is supposed to trump statutes, right? So that's sort of the hierarchy. Now, that doesn't mean that states can't pass laws. In fact, there's two laws in the state of Michigan. One is called abusive process, and the other one is called malicious prosecution. So we have two statutes that trump this common law exception. But at common law, if you don't have a statute, if a state doesn't enact a statute that says, no, you can sue us by our state actors, meaning the prosecutor, then you're stuck with absolute immunity, not even qualified immunity, which is what police officers have. So think Darren Chauvin and all that stuff, right? That was qualified immunity so long as he knows what he's doing, or as long as he doesn't know what he's doing is wrong, essentially, then he can't be prosecuted. But that's not what prosecutors get. Prosecutors under common law get absolute immunity.
Everything.
Judges
It's insane. Judges too, yeah.
Yeah.
Judges are interesting. Okay, so we'll talk about immunity real quick. You have essentially absolute immunity in the judicial system. So I can put something in a complaint within reason and file it with the court. And I can't get sued for, say, libel or slander or anything like that if it turns out not to be the case, right? Because they don't want a chilling effect on people going to court to redress their injuries. So you can kind of get your head around that a little bit. But when it starts extending to state actors with impunity, so the outcome of this case is literally that anything that the prosecutor does, hang on, I got to pull it up here, falsifying evidence, coaching witnesses, soliciting, and knowingly sponsoring perjured testimony, which, by the way, is grounds to get you disbarred, but you're not going to get sued, I guess. Withholding exculpatory evidence, all of that stuff is not grounds.
All right, so the thingers in my brain were pinging just now when you were saying that. So could it be that, and correct me if I'm wrong because I'm a normie. So if there's evidence of an agent of the state committing wrongdoing, can their prior convictions be overturned? Can there be other issues, domino effect for them if that's the case? So they kind of just go, wait a minute, nope, you can't come after us no matter what, because we don't want to open up the can of worms that could potentially lead to other problems for.
Well, so what we're talking about is individual or liability for the prosecutor, right? It doesn't mean that if they did something wrong that the people that are convicted their convictions get overturned and stuff like that. We're just talking
Okay.
about suing the prosecutor under
As an
common law
individual
for
or
the
the office?
both.
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 Yeah.
Okay.
Which is interesting, because what ends up happening is that you have actual crimes that are committed against citizens, which makes them victims of crimes.
Yes.
Then we have constitutional rights as victims upheld in just about every state. We have one in Wisconsin. I think that might be federally as well. So we have constitutional rights as victims of crimes that are supposed to be upheld. But then the immunity clause actually undermines our rights as victims, because we're not allowed to then go after the perpetrator of the crime, which is then the state or the prosecutor, or technically both, by defrauding the court, by, tampering with witnesses and everything else that they might do, which is a crime to any regular citizen.
Right? It's really hard to wrap
Yeah.
your head around it as just an everyday joke.
So okay, so how about let's start with this. We go back to medieval Europe, where we have absolute monarchs, right? The monarch is the law.
Right.
So whatever the monarch did couldn't be illegal because they are the law, right? So then we go from there and we start chipping away at it a little bit, and we shift from a monarchy to an elected representative. It's still the state, and what the state does can't be illegal because the state is the law. And that's how it's passed down through common law. We get all of our common law in this country from England, which had that system. So the state can't do anything wrong because the state is the law. And unless the state says you can sue it, you can't. So that's why we have things like government immunity. Just as a blanket rule under common law, the government is immune from civil liability. Now, the government can eat its own, absolutely. Like there's probably a statute in every state, some sort of neglective duty or something like that. And and so there could be criminal prosecutions for that. I know that the former governor in my state was charged criminally with dereliction of duty with the whole Flint water crisis thing. Those ended up getting dismissed. But the state can eat its own, but you as a citizen can't go after the state unless it gives you permission to. So
which is still
So
interesting,
crazy.
because even though the officer of the state has both created a victim out of the government, right, in violating their duty, in neglecting their duty, so they've both made the government a victim of their crime and the citizen. So the officer is then violating their duty and the rights of the citizenry, but then they're not allowed. Then you can't hold them accountable as a citizen. And this is where the paper, the Path of the Law, also speaks, because it talks about laws of tort. When we have legislature that conflicts with moral duty, moral responsibility, with our moral compass, and now we have tort applied to the citizen in this situation, where we have a conflict of morality that is not resolved by the law itself.
So that's just day one. And we haven't even gotten to the defense's opening statements. We had jury instructions. We had the state's opening statement. Then we had 10 minutes of the defense's opening statement, and then a whole host of arguments and nonsense. What did Gravely learn new today? There should be a daily segment, right? So what did Gravely learn today? He learned something, and I can't remember what the hell it was. He was like, Judge, I didn't know.
Was it argumentative question?
No, that wasn't today. That's probably tomorrow. What the hell did he learn today? You're like, we need to do a segment on Gravely's preschool lesson time.
He's been a prosecutor for 31 years.
What the hell was it? I'm gonna have to go back and look at that. If anyone in the chat knows, because
was it leading? Was that today?
No, it wasn't leading. There were no questions.
It was opening.
It was something.
So,
yeah. God, I can't remember what it is. I'm gonna have to go back and look. But I remember thinking in my mind about the whole argumentative question thing today, and there was something else that he learned today, and I'm just gonna have to remember what it was, and we'll talk about it tomorrow. Let's see here. Wasn't it about Denny? No, it wasn't about Denny. It was something else. I can't remember what it was. It's gonna bug me.
My head right now either.
Yeah, what he learned. Yeah. So, this is a fun game. Yeah, we're gonna have fun with this. Gravely's adventures of learning his job on the job. Yes, that's
Which
exactly
should
what it
terrify
is.
you because he
Oh, no.
he instructs this topic at a college in Wisconsin. So he's an
Yeah.
Oh,
instructor.
dear.
He's a teacher. This guy. And he's like, oh, I didn't realize that's an argumentative question. No. I mean, well,
God, what was it? Oh my God. I'm trying to think. I'm trying to think of what it was. Oh, this is gonna bug me. I'm not gonna be able to go to sleep tonight until I figure it out.
you're gonna end up like watching the whole damn thing over again, trying to figure it out.
It was during the argument part.
We've got the last couple of minutes. We don't need to perseverate on whether or not Gravely learned something today. We can recover that tomorrow.
Even if he didn't learn it, did he retain it for the next time?
You know, for a man who spent 30 years learning to manipulate the courtroom, because that's what he's really good at, because that's what I see when I watch him operate in that room. And that's why I wanted to really talk about him being the bad man, because he's clearly a bad actor. He's clearly trying to manipulate the courtroom. And I understand that you know, being in the courtroom is putting on a show, that you're presenting it, you're trying to be persuasive. But I see him taking it to the next step. And that's where you know, the lies that are told, when he talks about finding the body, when he talks about other things like that, that's intentional manipulation. When he identifies that spot as blood, even though it was never definitively decided to be blood or never definitively tested to be blood, when he does these things, this is dishonesty, this is manipulation, this is a violation, a dereliction of duty with malice. So it's not just negligence, it's malicious. So then we're going into malicious prosecution. But in, like we were talking about just yesterday, David, that malicious prosecution can only be brought back against the prosecutor if you're exonerated. And when will that happen? And so the way the law is set up, it still protects a bad actor like this. And what do we do other than raise awareness so we can try and advocate for change? Because that's the only way for us to do this.
Yeah, you're talking about the disingenuous thing. What I thought was interesting, the little bit that the defense actually got to get out during the opening statement, was that you will see reports from the medical examiner and from other crime scene, whatever, that this was a blunt force trauma death. You don't hear about an alleged stabby death until after Mr. Washington came forward with his statements. And you're going to hear more and more and more stuff like that, that just conveniently the stories change. Particularly the blood in the car and in the minivan, and Troffinger's, however you say her name, her email. So keep an eye out for that, because the state or the defense did mention that as well. The little bit of snippets of the stuff that got out. Keep an eye out for going forward.
Yep, and watch him manipulate the court. Watch him lie. Count it. You know, if you're gonna, you know, spend the time to watch this trial through again, those of you that have watched and are familiarized with it, watch how he lies, and he does it very carefully. He chooses his words. Like when he mentioned the knife, he actually uses a disqualifier. He said possibly a knife.
Yep.
When he was talking about arterial spray. So he's intentionally trying to infer with avoiding consequence for then being able to be quoted as defrauding, because those little words matter when you're going to a higher court or going to the Office of Lawyer Regulation to argue that he did defraud, because then they can say, well, he disqualified it. He didn't say definitively.
Right. Ugh. I hate it.
Jess, any parting words Or are you going to be watching with us? What are your, I guess, instruct the chat. What do you want them to do?
Well, I'm going to be watching with you guys, and catching up every evening. Is this every evening that you're doing this for the
Every
next
evening.
Every
2
evening.
weeks? All
Yep.
right, then I will be in the chat with everyone else tomorrow night. But yeah, this is great. Thanks so much for having me on.
Oh, thanks for
And
coming.
it's nice to meet you, Solomon.
It's been a pleasure.
Oh, you guys have never met before. This is
yeah,
interesting.
Not
I
on
didn't know that.
stream.
Yeah.
Oh, okay.
I mean, sorry that I ranted so much during this. Jen
good.
was trying to tell me to learn to shut up because I'm boring. She told me that this whole thing is going to be boring.
What?
Never.
She doesn't know what she's
Never.
talking about. I'm gonna drag Jen onto the stream, and we're gonna see who's boring.
She's way more funny than me.
Thanks everybody. Remember, so every day, every weekday, Monday through Friday, until we're done, at 8 a.m. Central, 9 a.m. Eastern time, we're going to be restreaming the trial day by day, and then we're going to be right back here at 10 p.m. Eastern, 9 a.m. or 9 p.m. Central. Oh my God, so confusing to me. I don't know where the hell I am.
David
and whatever
time
time Jess is, it is for Jess. What time is it there? Is it still
almost
morning?
8 o'clock.
Oh, okay.
So I'm a little late start for your streams, but I get there eventually.
All right. Very good. Until tomorrow. We'll see you all right back here. All right.
Thanks for
Take
being
care,
here,
all.
everybody.
Oh yes. There we go.